Did the states have clear notice that by accepting Medicaid funds, they would be subject to vaccination requirements for staff at their state-run facilities?
So the facilities, and this applies to all facilities in Medicaid and Medicare, not to the states as the administrators of their own Medicaid programs, but I acknowledge states do have state-run facilities. All of them are on notice that they're subject to the health and safety requirements that the Secretary may adopt from time to time. Obviously, they didn't have specific notice of the vaccination requirement because it didn't exist until the pandemic came about, but the way that the program operates is that all providers are on notice that they have to comply with the Secretary's regulations, which could change.
So if they read the statutes that you are now relying on primarily, that would provide them clear notice that they might be subject to something like this vaccination requirement?
It would put them on clear notice that they are subject to such requirements as the Secretary finds necessary in the interests of patient health and safety, which have long included infection control. In the past, that's been general. It's been requiring infection control plans that meet national guidelines, fire preparedness, emergency safety, things of that nature. So they have long been on notice that they are subject to requirements by the Secretary in the interest of patient health and safety. And I think this is a sort of heartland case of a measure to protect patient health and safety in the midst of a pandemic.
I don't have before me the particular statutory provision that you spoke of earlier, but is it the case that some of many, if not all, of these additional statutory provisions on which you are now placing your principal reliance are definitional provisions rather than provisions that expressly authorize the Secretary to promulgate regulations? Is that correct or incorrect?
They're both. So they are definitions. The provision I quoted earlier, 1395XE, is the definition of a hospital for purposes of the statute.
Right.
But in that definition, it says a hospital, and what it means to be a hospital is to be eligible for Medicare reimbursement. What it means to be a hospital is to meet the following specified requirements, including such other requirements as the Secretary finds necessary. So,
right. But it doesn't say the Secretary is authorized to promulgate any regulations that protect the health and welfare of people in a hospital or in any of these other facilities. It says that the definition of a hospital and the definitions of these other facilities, by definition, they are facilities that are required to comply with regulations.
As the Secretary finds necessary in the interest of patient health and safety, yes.
Is there any limit to that power? What could the Secretary, what, if anything, could the Secretary not do if the Secretary finds that something is necessary to protect the health and safety of people in those facilities?
Well, I think the major limit is the one in the text of the statute itself. The Secretary has to find that it's a requirement that's in the interests of patient health and safety, as the Secretary did here. I think the other constraints on that authority are the types of health and safety measures that you see in healthcare providers. So, and the way you know that this provision is within the Secretary's authority is that you see providers adopting it on their own. You see medical societies like the American Hospital Association, the AMA, the American Nurses Association recommending this policy. You see some states adopting this policy. I think all of those things are powerful confirmations that this is a routine, common, effective measure for protecting patient health and safety.
One of the arguments on the other side is that you were required by statute to consult with the states before you did this. What is your response to that?
There is a provision of the statute that says that when the Secretary sets conditions of participation for some of the providers at issue here, in carrying out that function, he shall consult with the states. The statute doesn't say that that consultation has to happen before rulemaking, and the way that the Secretary has long understood that to function is to require consultation in conjunction with the notice and comment process.
Isn't that an odd understanding of a consultation requirement? We're going to tell you to do something, and then after we've told you to do it, we're going to consult with you about what we've already said you have to do.
I don't think so, Justice Alito, in the context of the provisions of the statute that also contemplate, as the APA does, that in some circumstances the Secretary will have good cause to act without notice and comment. So in the ordinary case, there's going to be notice and public comment, which has the benefits that Justice Barrett referred to earlier. When that happens, you should also be sure you consult with the states and with accrediting boards. But when there's good cause to skip that, the agency has long interpreted that to mean that it can defer consultation with the states to the parallel public comment process.
Is there a good good cause exception in the provision that requires consultation?
There isn't, but there's no temporal requirement at all. So it's actually the other side that's asking you to read into that a requirement that had happened before rulemaking and to make that requirement apply even when the good cause exception is satisfied. And we don't think there's any basis to do that, certainly not in the Secretary's past practice. This has long been the way that the Secretary has interpreted this provision in conjunction with the good cause exception to notice and comment.
Mr. Fletcher, can I follow up on the questions that Justice Thomas and Justice Alito have been asking about the facility-specific statutes? I think it was wise to shift your focus to those because of their references to health and safety. But I find it difficult because the language of each of those statutes is different, and not all of them reference health and safety. So, for example, I think the one on long-term care facilities is your best, because that's the one that also refers to or requires skilled nursing facilities to establish and maintain an infection control program. That one, I think, gives you a stronger case than the ones that don't mention health and safety at all. Or, for example, for ambulatory surgical centers, you know, the provision on which you rely describes the benefits provided to an individual, and then it lists the kind of services that would be covered, right? And then parenthetically, it says, performed at an ambulatory surgical center, parentheses, that meets health and safety and other standards specified by the Secretary. It seems to me a heavier lift to say that that kind of aside in a parenthetical is a grant of authority to CMS to impose this kind of vaccination requirement on those who work at the ambulatory surgical center. So I guess my question is this. One, you know, the government here seeking the stay of the injunction has the burden of showing likelihood of success on the merits, and I understand because of space limits and the number of statutes on which you're now relying, it would be hard to make the specific case for each of these provisions. But what if I think some of the provisions might support you and others don't? This was an omnibus rule, and even though the Secretary in a chart identified all these, you know, specific provisions, we don't really have before us the structural and textual arguments directed at each of these provisions. So what if I think some do and some don't? In an omnibus rule, what am I supposed to do?
Well, so we agree entirely that the focus ought to be on the statutory text, and one of our complaints with the district court decisions in these cases is that they blew past all of those distinctions and didn't focus on the text at all. So we absolutely agree the text of these provisions should be the court's focus. In terms of how to think about them, I understand it's unwieldy. There are 15 different provisions. I would group them into two categories. There are 11 or so that we cite at pages 5 to 6 of our reply brief that include that specific health and safety language in different formulations, but all of them specifically referring to requirements in the interests of patient health and safety. And as we've explained, we think that this is the paradigmatic health and safety regulation, and that's reinforced by the consensus of the medical community, by other regulators, by practices of providers. Now, there are a few statutes that we cite at page 9 of our reply brief that don't include that specific language. Those statutes are the ones applicable to providers that employ about 3% of all of the workers covered by the rule. Now, our view is that all of those statutes still give the Secretary the authority to set standards or requirements for participating providers. And if you look at those provisions, what you find is that Congress was a little bit less detailed. In the hospital provision, the 1395XE9, the preceding 8 sections all detail relatively nuanced, very specific requirements for hospitals. And then